My name is Ethan Ordog, and I'm an attorney with the Begley Law Group. I have been asked today to discuss the process for guardianship in New Jersey. For many parents, the determination to pursue guardianship comes from the realization that it is necessary to establish a protective arrangement for their disabled child to ensure that decisions can be made in their best interest. The process itself is somewhat simple, although often requires counsel or other assistance to ensure that it is done properly. The process begins with the filing of a complaint, which sets forth explanation of the physical or cognitive limitations of the disabled child, as well as any assets, residential considerations, or other care plans that might be appropriate for that individual. The court that hears these matters will set a hearing date. They will appoint counsel for the alleged incapacitated person. With our filing, we need to present the certifications of two physicians who certify that the alleged incapacitated person requires a guardianship, that their cognitive or physical limitations are such that they cannot manage their affairs or make decisions on their own behalf. In many instances, especially with disabled children and the circumstances that have prompted that filing, the court will often attempt to establish what is known as a more limited guardianship, one that in scope reserves rights to the disabled child to make decisions for themselves in certain areas while allowing the appointed guardians, in most instances the parents, to make decisions on the more formal decisions, legal matters, financial matters, medical decisions, residential living arrangements. Ultimately, the attorney who is appointed to advocate for the alleged incapacitated person will submit a report to the court detailing their position, the rights that are to be retained, and who will make the best guardian for that individual. A judgment is entered, and the guardians ultimately qualify to serve on behalf of their disabled child. This is an important step in the process of making sure that a disabled child is protected and that their rights are, number one, advocated for, and number two, that all decisions are made in their best interest.